Thank you, President Carl.
Hold on one second, Rich. Go.
Thank you, President Carl. It's my pleasure to introduce my wife, Karen Carroll, today as our speaker. Karen is currently an associate justice on the Vermont Supreme Court. She moved to Brattleboro back in 1988. She worked as a deputy state's attorney for 13 years. In 2000, she was appointed as a Vermont Superior Court judge by Governor Dean. And in 2017, she was appointed by Governor Scott as an associate Supreme Court justice. And Karen is going to talk today about how the court system in Vermont has responded to the COVID adversities. So I will introduce, and it's my pleasure to introduce Justice Karen Carroll.
Thank you. Thank you, Attorney Carroll. So I'm really happy to be here. I was happy that Rich asked me to come. I think it's important that the public understand what one of the branches of government is doing in the face of the COVID epidemic in an effort to keep citizens safe. After all, many of you might be seeking access to the courts or might end up in court, whether you like it or not, with a jury summons. So I thought this would be helpful to all of you. We've really put a lot into the COVID epidemic and trying to pandemic and trying to make our courts safe, not only for those who have to enter into the courts, but our staff and judges as well. My job was probably 80% researching, reading cases and writing opinions until this pandemic struck us. And now I would say 80% of my job is working with the court on managing this issue. And so I know a lot of you have been subject to a lot of changes with respect to your jobs, how you do your jobs, and I hope you find this interesting. I'm happy to take questions. I have a PowerPoint that I'm going to be putting up. I'm happy to take any questions from anybody. I don't know that I'll see them, but I don't mind Rich or Marty or whoever runs the Zoom to interrupt me when I'm talking. And we can keep this very informal. Just so you know, the only person I ever make call me Justice Carroll when I'm not at work is my husband. So the rest of you are off the hook. All right, so I'm going to share my screen. So I've just explained that and please someone let me know if this isn't being seen well or there's any issues with it, but I'm going to be talking about our response to the COVID pandemic.
Carol, is that screen supposed to be up now?
Yeah, is it not?
It's not.
Huh. Okay, let me just try something else then. Trying to share my screen, but well, I guess we will not be using a screen of PowerPoint. Sorry about that.
There, it's up now.
Is the PowerPoint up?
New to working from home.
Oh.
Oh, I'm sorry.
I'm really sorry. Just give me 1 second.
There you go. That's good. We can see that
How's
now.
that? How's that? Good? Okay,
Perfect.
so please, again, interrupt me with any questions you might have. I thought it might be helpful to start with kind of an introduction of the Vermont court system. I see Ted Kramer on, I see George Anthony's on, and of course, Rich, I'll know about this, but I think it is helpful to how we get to the point of the Supreme Court making policy decisions. So the Vermont court system is comprised of a superior court system and the Supreme Court. The Supreme Court Criminal Division does handle all criminal trials. That includes felonies, the more serious charges, as well as misdemeanor offenses. And some, as I've indicated, they're traffic appeals. The appeals that some of these, what we call original jurisdiction courts, handle are appeals that don't go to the Vermont Supreme Court. The Family Division is comprised of a magistrate who handles child support cases, a family division judge who is involved in domestic violence cases, the RFA hearings. You might hear about, people call them restraining orders, but they're actually called relief from abuse orders. The family division also handles all our juvenile matters, and those are essentially divided into two categories. One are the delinquencies, wherein a child of a certain age, it depends on what the crime is referred to the family division delinquency court to have his or her charge resolved there. Those become confidential. The other segment of the family division juvenile portion is what we call CHINS cases, children in need of care and supervision. Those are children who are parties to cases where there has been abuse, neglect, or unmanageability or truancy. And we have seen an explosion in these types of cases since the opioid epidemic arose, where as a trial judge, I, for 17 years, did maybe 10 termination of parental rights cases. We've had hundreds over the last 4 to 5 years. So that's a issue that we're really struggling with. The probate division handles estates, guardianships, adoptions, and some other things. The civil division, which as you all probably know is in Newfane, the original jurisdiction there is civil suits, small claim suits, also stalking, which are like relief from abuse cases, although they involve individuals who are not people who have lived together or been intimate partners. And the civil division will get appeals from the probate division. Finally, and I should say that those first four categories are in every single county. They might all be in the same building, they might not be, there might be separate buildings, but every county in this state has a superior court with those divisions. And then we have the environmental division, which is part of the superior court, but that is only at one site. That is in Chittenden County, but it does handle cases where land use is involved. There are sometimes Act 250 appeals, things of that nature. It's one site, but it covers the entire state. And those of you who know just Judge Durkin, he and another judge preside over those cases. So then when we get to the Supreme Court, there are 5 of us on the Supreme Court. We take appeals from the Superior Court. So all those courts that I just named, and almost everything they do comes on appeal to our court. I would say we get about 500 appeals a year. We don't resolve all of them. Some of them get dismissed prior to coming to an argument before the court. And so we probably issue about 300 decisions every year. Some of those are opinions that are issued by the entire court, all 5 justices, and some of those are 3 justice panels. We have, for about 20 years now, been holding what we call rocket dockets, which are shortened arguments with only 3 justices on cases where no kind of new law will be made, or the issues in the case as far as the legal aspects go are pretty well settled, and that those cases are mostly fact-based issues. We also get direct appeals from the Professional Responsibility Board. That is the board that the court has appointed and the court oversees to regulate the practice and discipline of attorneys where ethical rules are violated. And it's the same with the Judicial Conduct Board, where we appoint a committee to look at complaints against judges, determine whether any of the judicial ethical rules have been violated, issue decisions, and then those come on direct appeal to us. We also take extraordinary relief appeals, and what those are appeals where someone has no other relief in court. And a good example of that is a person who's arrested, say on a Friday night, charges, if they're held in jail on bail, need to be brought by Monday, and that person would go to court on Monday. For instance, if a person just continued to be held and no charges were filed against them, and so they couldn't go to that criminal division and ask for relief because there is no case from which the court could make a ruling, a petition could be filed with the Vermont Supreme Court to ask for relief. Unlike the US Supreme Court, the Vermont Supreme Court basically takes any appeal that comes to it. Most appeals are as of right, where the US Supreme Court, as you all probably read about, makes the decision what types of cases they are going to take, and we don't have that luxury. It varies from state to state how the court is or is not involved in policy making decisions. Some states are bifurcated so that their Supreme Court handles just only what I was just talking about, appeals coming from the various courts and entities, and then has a separate court administrator system and policy making entity. And the Vermont Supreme Court here in Vermont, we oversee the entire system. The 5 of us make, with input of course, all the policy decisions for the courts and justice in the state of Vermont. And these are just some of the types of individuals whom the court oversees on this list. So then came COVID. And I started with this screen because I just wanted to let you know that when we talk about COVID and our response to it, we follow science. We are in constant communication with the Department of Health. We follow the CDC guidelines, and we also are mindful of the governor's executive orders. And not only mask wearing, but social distancing is a huge part, as you all know, of the response to the pandemic. This slide is just a snapshot, and there are probably more individuals that should be on this slide. These are all the types of people that we have in a courthouse on any given day. Parties, We have people being transported in for hearings from prisons where, as you all know, there have been outbreaks of COVID. And so that's pretty difficult to manage, bringing those individuals into the courthouses. Victims of crime have certain rights to be notified and present at hearings. People have a right to, in certain cases, support persons being with them in court. Of course, the media, all the security, the guardians ad litem are those individuals who work mostly in the chins and delinquency dockets, helping and representing children, and probation officers, staff, judges, jurors, and the public who have a right to access the courts and take a look at what's going on and what types of decisions are being made. These are the types and groups of people that we have to now manage with respect to how we are going to allow access to our courts. And we're not like a restaurant or a bar or a store where we just need to be concerned about the COVID restrictions and how we're going to manage them, how we're going to have enough staff to be able to manage and earn money. We are guided by constitutional considerations that we just cannot ignore. I have a question. Is it showing pictures on the side of the screen too? Or are you just seeing the screen? Okay, good, because for me, I can see certain people's faces and I want to make sure you're able to see the screen. And so these are all rights that individuals have pursuant to the Bill of Rights. And these are rules that we can't just decide, or these are rights that we just can't decide to put aside when we decide how to make our courts accessible during a pandemic. And some of them raise significant issues, especially rights in criminal cases. But I'll start with the press. When I was a trial judge, I would say 80% of the time there was someone from the press in the courtroom. We can't tell the press that they can't be present in a courtroom, or at least we can't provide them access to what's going on in the courtroom. We have since made some strides with the press by if they have asked us to live stream, we're going to get in a little bit more into remote hearings, but if they have asked us to live stream a particular hearing of interest, we have done that. And that seems to be something that is okay with them, but we certainly need to make the courtrooms available to the press. In the Sixth Amendment, the third one down in that description, that is where we're the most frustrated, and honestly, most of our work in the last almost a year has gone into. We have detainees who have been in jail now for the entirety of this pandemic who are waiting for their jury trials. Some of them are being held on very low bail. Some of them are being held without bail because they've been charged with offenses that don't entitle them to bail. And we have had to put all those cases on hold because we are not at a place yet where we can hold a jury trial, although I think we're close, and I'll explain a little bit about that. But the Sixth Amendment guarantees defendants a right to a speedy trial. And we certainly are seeing in the trial courts and sometimes on appeal claims that speedy trial rights are being violated by the court not conducting jury trials at this point. Again, I'll reiterate, we have a dual responsibility to not only ensure constitutional rights are being followed, but we also have a duty to protect our staff, witnesses, attorneys, and everybody else who comes into the courthouse. The last one, the Eighth Amendment, excessive bail nor cruel and unusual punishment may be inflicted. Here because there have been COVID outbreaks and individuals who are being held on bail or without bail, we've had a number of arguments that they are subject to a violation of this amendment because they're being held in prisons where some of the population is COVID positive. Although I think the Department of Corrections has done a really good job on trying to keep those individuals separated. But anyway, my point being, we've got more than enough to consider already, but we have these constitutional considerations that we can't ignore. The court usually makes orders by issuing written opinions on cases. Oftentimes we adopt procedural rules as to how court cases are managed and the rules that apply to them. We do that by notice, comment, public comment, and then promulgation after we receive comments. So that, as you can imagine, takes quite a period of time. We sometimes hint in an opinion that the legislature should take a look at certain statutes that we find ambiguous or problematic. And as you know, that takes quite a bit of time as well for the legislature to go through amending a statute. But what we have the power to do is issue administrative orders. And so this slide is about Administrative Order 49. This is an order we put in place at the start of the pandemic when the governor issued his administrative order, his emergency order, and we followed suit with one similar to that for the judiciary. The guidelines, again, are his order, the CDC and DOH, and the science and safety requirements behind it. Now, as you know, we've had resurgence of the virus. We've had now variants of the virus. And so things change. This order has been amended 19 times because we go with the flow. Whatever seems to be going on with the pandemic, we try to adjust our order and what it allows and doesn't permit as a response to that. It originally only authorized emergency hearings in the courts, but there was a committee assigned by the court, which I sat on, which was the long-term planning committee ramp-up report issued in May of 2020 that gave guidance and recommendations as to how to start holding hearings again once the numbers started to go down a little bit. Again, we had a jury trial restart committee. I co-chaired that. That was in July of 2020. A report was made to the court as to what needs to be done to safely hold a jury trial. That order is still in effect, and what it today looks like is that it mandates remote hearings except for jury trials, except for evidentiary hearings in the criminal division. An evidentiary hearing is a hearing where witnesses will be called and evidence will be presented. And that's the same for juvenile delinquency hearings because they follow the criminal rules. Parties may file most documents by email now rather than having to mail them. We now have a new case management system, though, that most things are done by email anyway. We've used, I should get back just one moment to the remote hearings. We did get some CARES Act funding from the legislature, and a good positive result from this pandemic and our use of remote hearings is that we've really improved our infrastructure around the state to allow for these types of hearings. And we hope that after the pandemic, we'll continue to be able to use this. For instance, if you've got an attorney in Burlington, who has a case in Brattleboro and would love to not have to drive all the way down. That attorney from now forward would be able to make a request for a remote hearing. And if the court grants that, that can be very useful, save attorneys time, save parties time, and save people paying those attorneys money as well. We do currently restrict access to our court buildings to all of those other than judges, judiciary employees, some contractors we have, and those have been the people installing the infrastructure for the remote hearings, and those essential to those types of hearings I said weren't covered by the remote hearing requirements. It also exempts registered members of the media so that any person who registers with the court administrator's office as a media member has access to the court as well. We conduct regular screenings of those who enter. We require masks, where we've just now upgraded to a level 3 mask that we are requiring those entering the courts to wear. We have required under AO 49 that all judiciary meetings, I've already talked about the hearings, but that the committee meetings all be done remotely. We in fact held our first remote bar exam in October. It was supposed to be in July, but the court got that together. It was done remotely in October and in fact went very well. And the next bar exam this month is actually going to be done remotely as well. And a lot of states have been doing that. We give, as I said earlier, priority to juvenile cases and criminal cases with respect to those who are incarcerated. I want to let you know what we've done about trying to get a jury trial in place. It's been a lot of work, I can tell you that, and very expensive as well, but we have been able to use a lot of the COVID money for these purposes. We have hired a professor of epidemiology, Dr. Aaron Bromage, as a consultant. He is regularly on CNN. He was on PBS News the other night. He's a well-known expert on pandemic issues. He has come to some of our courts, inspected the courts. We consult with him weekly. He also holds a conference call once a week with all the New England state judiciary, both judges and staff, administrators, to answer any questions that they have. One of our big issues about starting jury trials is HVAC system, airflow systems. You've seen a lot of the courts in this state, including Newfane, are historic places and not as renovated and current as the state court buildings like the one that you see in Brattleboro. The issue is that the judiciary owns none of those buildings. The state owns the bigger buildings, and the civil divisions, like in Newfane, are owned actually by the county. So we, as the judiciary, don't put money into those buildings. We just have to make the requests that it be done. And so we've hired an engineer who is inspecting and making recommendations and approving what buildings can and cannot withstand enough people to be involved in a jury trial. You think about 12 jurors, you think about all the staff, all the witnesses. We need adequate airflow. This is something Dr. Bromage says is a must. And so we're making requests for BGS and the county-owned buildings, the assistant judges, to make necessary changes to their airflow systems to at least the least they can do is put in standalone filtration systems, but we prefer HVAC systems, and we're involved daily with these inspections being done and this work being hopefully completed soon. We've had to reconfigure our courthouses, reconfigured courtrooms. As it indicates, we've installed plexiglass in courtrooms and around the jury boxes, around the judges, the attorneys, the clients, the jurors. And it's not a courtroom like you have ever seen if you turn into, you know, Dateline and watch a trial. We've got things moved all over the place now. Jurors likely won't be sitting in jury boxes. They'll probably, once we start this, be sitting out in the galley where people usually sit to view a jury trial. And so that will limit the number of people from the public who can come in, which is another reason we've really ramped up the use of live streaming so that the public can still have access to what's going on in the courts. And for instance, a lot of courthouses like the one in Brattleboro has 3 courtrooms, and there might be 3 judges sitting in one of each of the courtrooms at the same time all day in Brattleboro. When we do a jury trial, we are going to have to use all 3 courtrooms in that building for a trial, and nothing else will be able to get done. No family cases, no juvenile cases, because we need the whole courthouse. And you wonder why? Well, it's because we need rooms big enough for jurors to be able to go sit in and social distance 6 feet apart, not only for orientation, but for lunchtime, and then that needs to be cleaned. And then they would go to another room for their deliberations, and they have to be kept 6 feet apart. So once we start getting a jury trial up and running, you're talking about using an entire courthouse, not the usual courtroom that we're used to. A few other things we've done are amended juror summonses and engaged in a public information campaign. So we may all think that what we're doing is going to make jurors safe, and we hope that it is. We're comfortable that we won't start a trial until we can ensure that, but it's hard to tell a juror that, right? It's hard to receive a jury summons and be comfortable thinking that you're going to go into a courthouse with a pandemic going on and be safe. So we've amended our summonses to jurors. They now say that we've done everything we can to bring you in here safely. We want them to give us information about any pre-existing conditions they might have, any major concerns about COVID. And the interesting thing about that is where we might have before summoned 100 jurors for a trial, because as you know, jurors get excused for various reasons during the process of selection. We now are summoning more than 200 jurors because we know people are either not going to show up or are going to have such concerns that it's not worth bringing them in. They're not going to be able to focus, so they get excused. That's everything, not everything probably, but what came to mind for me about what we're doing and the hard work the judiciary's put in trying to get a jury trial started and keep people safe. So where, you may ask, is the first criminal jury trial going to happen? And that is right here in Windham County. And that is really for several reasons. It's because our building is large enough. We have the 3 courtrooms. We can manage the spacing with the jurors and the public and all. We have an HVAC system which is about to be approved. We know it's appropriate. We have a clerk here and a judge here who work really, really well with the judiciary and all those individual contractors who are coming in and out. And we also had Dr. Bromaj come in and inspect that courthouse, and we have okayed it. We were supposed to have a trial starting last December, but it got canceled because that is right when the numbers were going up and all the and the deaths in the state were increasing as well. So we didn't think that was a good time to start a jury trial, but we have now a targeted date of the end of March, mid or the end of March for that. And that will be right in Windham County. And so my final thought is sort of unrelated to this, but it's something that I am very interested in and heavily involved in. And that is that in 2020, there were more opioid deaths in Vermont than ever before. There were 134 deaths in 2020, and that eclipsed the 2018 number of 130. And that is, as I think, and from what I've read, a direct result of the stress and mental health challenges of this pandemic. We continue as the judiciary to operate 4 addiction-related treatment courts. We have drug treatment dockets in Rutland County, Washington County, and Chittenden County. Those are courts, some of you may know, who work closely with individuals charged with criminal charges. I think I did say the DUI treatment docket in Windsor. That one focuses on repeat DUI offenders, where we get them into treatment, we monitor that, and if they do, it could take 18 months to 2 years to do everything expected of them, but they get a better outcome on their criminal case. It's not dismissed. Many of them still serve jail time, but they serve less. And those have been very, very successful. And finally, and court appearances and treatment have been pursuant to those dockets, been able to be done remotely. And finally, Vermont is participating in the New England Regional Judicial Opioid Initiative, which was a collaboration of all the chief justices of the New England states. I am the chief justice's designee to this, and what we're doing as New England states working together is developing multi-state, multidisciplinary responses to the opioid epidemic with a focus on courts and criminal justice system, but also on the parents in the CHINS cases, the abuse and neglect cases, who often have substance abuse issues. That's the PowerPoint. I think I'm back there. Be happy to answer any questions unless I talk too long.
Marty, were you saying so? You're still muted. There you go.
No. Thank you so much for your presentation, Justice Carroll. There's been some questions in the chat. If I could just, if you have a
Sure.
moment. All right. First question was, have there been any studies on the efficacy of drug treatment courts?
Well, someone probably asked that maybe before I started talking about it, but yes, drug treatment courts are being used all over the country and with very, very favorable results. I think the public perception of them sometimes is that someone's going to get a slap on the wrist and be able to participate in a treatment docket and get treatment that they should have gotten on their own. I have to say that I sat on a treatment docket as a trial judge up in Windsor. I was the first judge to sit on the DUI treatment docket, and it was the most fulfilling work I've ever had. These are people who need direction. They've committed a crime and they will get a sentence. And as I said, often jail time. But the oversight from a team and a judge, studies show, goes a long way to completing tasks and participating in treatment. And the other really important aspect to it is that you are doing this in front of your peers. So everybody who's a subject of that treatment docket, anyone who has the charges and is referred to the docket, comes in every time there's every other week. So every time there's a hearing, and has to get up and speak about what they've done right and what they've done wrong in front of their peers, which also has been shown to create compliance and responsibility among the participants as well.
Thank you. Another question. Were the counties able to access CARES funding to improve ventilation systems as well as other modification to improve safety of the space during COVID?
Well, as I indicated, some of the buildings are owned by the state. So that's the courthouse in Brattleboro, the big brick building. That building is owned by the state. And the state does have CARES funding through the Buildings and General Services branch of the executive. And so I know that they're using that in going about doing the studies and potentially improving the HVAC systems and the filtration systems. I think also, I heard yesterday that at least in Windham County, the Newfane courthouses, the assistant judges are interested in accessing that money as well to update the systems there, because the problem is with those county buildings, if we can't have our engineer go in and say this is safe, there just won't be hearings in those buildings. And some of the counties don't want to make those changes given the historic nature of the buildings and the work that would have to go into them and some of the infrastructure that might not meet the historical building type requirements.
Thank you. And the last question on the chat is, do you have any comments on the suit brought by members of the Public Defender's Office to block the rollout of the new electronic filing system, which I would have expected to be a boon in COVID times?
That's the easiest answer I'll give all day. No comment.
Okay.
because I can't, that is something that if there's a lawsuit, it may come up to the Supreme Court. So I'm not able to comment on that.
Thank you. That's all the questions in the chat.
Okay, great. Well, thanks for having me.
Karen, thank you for coming. We appreciate it.
Yeah, and if anyone ever has any questions, feel free to let me know.
Okay. And thank you, everybody. Have a great afternoon, and we will adjourn the meeting. See you next week.